Hi, I'm your host Marcus Rees-Evans. This is part of our continuing series on top 10 reasons why it's reasonable, rational, and needs to happen right now for Californians to discuss a more independent California. The fact is that California elected leaders have already publicly worked on forcing the state of California to comply less with federal law, to work less with the federal government, and to frankly not share information with the federal government. So California elected leaders that you have put into office are already moving the state to a position where it frankly operates more independently and less with the federal government. But let's start off with 2012. Assemblyman Tom Amiano of San Francisco created the Trust Act, also known as AB 4. What it said was that the federal government's program, if an undocumented Californian was arrested for any minor offense, the federal government immigration officials could simply call that local police authority and say, hold on to that undocumented person till we get there. This meant that people who had caused a traffic violation or had some minor offense would be held additional days in jail till the federal government felt like picking them up. This is independent on if that person has actually committed that minor offense. You were accused of committing a minor offense, you're brought into jail, the federal government says, oh, you appear undocumented, wait there even longer than what your offense would hold you there. Days, much longer. Additionally, because of, quotes, database foul-ups, citizens, U.S. citizens, California citizens, who were accused of being undocumented were also held longer than the law would allow for their minor offense. In addition to undocumented people who were rightfully called undocumented, also being held longer than their offense. Tom Amiano's Trust Act, proposed in 2012 and approved in 2014, says that the federal government will no longer, that says that the California state government, will no longer work with the federal government on handing over undocumented people or providing information to the federal government on undocumented people. The California state government has been ordered to direct its police and other policing officials to not cooperate with the federal government on telling them when they have an undocumented Californian in their midst, period. Let's move on to 2013. Attorney General Kamala Harris ruled that complying with the federal government's rules for holding undocumented Californians was, in fact, discriminatory and not in keeping with California law. And therefore, she ruled that California legally shouldn't have to comply with the federal government on holding or informing the federal government of undocumented Californians. But it gets better. Let's move to 2014. Assemblymember Luis Alejo proposed and was passed AB 1660. Now, many of you know this as the driver's license for Californians who are undocumented law. And while it does that, it also makes a provision that the DMV, when collecting information from Californians who are undocumented, will not share that information with the federal government. So the California state government has directed a California state agency to not cooperate with the federal government. Our Attorney General gave a legal reasoning the year before saying that. And the year before that, all of this in just the last 4 years, another person in the legislature passed a law saying that California police forces are not going to cooperate with the federal government on undocumented Californians. That's 3 different examples of your elected officials saying that California state should not cooperate or share information with the federal government.